She has a $720 car payment, which is high above anything that defendant owns, and she's residing in a home that she can't afford. She's provided absolutely no proof that she is looking for alternative employment. It seems that she's simply just sitting at home and collecting a paycheck. Plaintiff had an extramarital affair.
The court will note the appearance of Mr. Todd on behalf of the plaintiff, Ms. Capture on behalf of defendant. We have two motions. We have plaintiff's motion for spousal support and other relief, and defendant's motion for exclusive use of property. I did have one question, and maybe you can enlighten me in this particular matter. Mr. Todd is okay. Hold on. Sorry, I miscaptured. Where there was this $29,000. I saw all the pleadings, and there was supposed to be a division of this account, and then it was quite confusing over what happened. Was it divided, and does half of that still exist someplace?
Yes, Your Honor, it was divided. My client has his half of the monies, and then the other half, Mr. Todd informed me that Ms. Doubleday might not have access to the account that it was originally transferred to. However, the money was, her half of those funds was transferred back into that joint account and still reside there.
So it's in the joint account. She has access to that account, correct?
Yes, Your Honor.
Well, the court will order that she's entitled to receive and access those one half of those funds. It was in the amount of $29,231.11, and so that will be available to her. With that, Mr. Todd, you can proceed with your motion.
Thank you, Your Honor. Your Honor, would you also like me to address the exclusive use as well?
Yes, go ahead.
Okay.
Well, I've received your response, so I know what you're arguing.
Okay, and I'll just limit it to that for exclusive use. We are requesting that continue, or otherwise Mr. Doubleday be required to move the tanning bed and provide a printer for Miss Doubleday to use. In relation to the spousal support, it has been the status quo since April that the parties deposited their checks into this joint account, and then these set bills would be paid out of the joint account. Plaintiff only gets $1,250 net bi-weekly. Mr. Doubleday's income is approximately 2/3 greater than that. In the answer, I believe that it's indicated that Mr. Doubleday, in essence, would continue to pay half of the mortgage, half of the insurance, half of the taxes, half of the phone, half of a car insurance payment. I believe that is, in essence, the answer. However, even when you factor in that, there's still a $600 deficiency for my client's fixed expenses. We believe from a pragmatic standpoint, it would make more sense for Mr. Doubleday to simply continue the status quo of depositing the $21 per paycheck, which he has been, into the joint account, or alternatively, that he be required to pay 2/3 of all of those fixed expenses that he outlined, because his income is 2/3 greater. Ms. Doubleday has been trying to find other employment actively, but has not been successful in doing so. Additionally, the defendant will argue that he's paying $1,500 for an apartment. That is an apartment to his sister. Today, as of today, again, I reviewed everything. There are 3 2-bedroom apartments for less than $1,000 in Marshall, and there are over 15 2-bedroom apartments for less than $1,000 in Battle Creek. So we believe that this is a inflated expense, and from a pragmatic standpoint, that the status quo should continue. We did need to file this motion because originally Mr. Doubleday did in fact remove that $30,000, and Ms. Doubleday did not have any way to access that. Subsequently, we filed the motion, and it's my understanding that there has been half of the money returned to that joint account, but that was not prior to us filing this motion.
Please move on, Mr. Todd. I don't care.
That's all.
Care now.
That's all.
Okay. Ms. Capture.
Thank you, Your Honor. As we stated in our answer to plaintiff's motion, defendant has been paying for his portion of the marital bills. We have offered multiple alternatives for plaintiff to no longer reside in the current home that she's staying in. We've asked to sell the property as it is beyond both of the parties' current expenses. So at this point, any deficiency that is in plaintiff's budget has largely to do with the fact that she has a $720 car payment, which is high above anything that defendant owns, and she's residing in a home that she can't afford. Furthermore, Your Honor, she's provided absolutely no proof that she is looking for alternative employment. We haven't seen any resumes sent into any kind of like work requests. We have absolutely nothing other than her word. It seems that she's simply just sitting at home and collecting a paycheck. Again, Your Honor, if they're asking for spousal support, there is a particular way to request for that. The statute is very clear. There are 14 factors according to Olson v. Olson. None of those have been enumerated within their motion. Your Honor, this simply is not a spousal support case. There's no real need here. Plaintiff lives beyond her means, which is clear, and she has simply not looked for alternative work. Defendant continues to pay all of his portion of marital expenses, plus the new expenses that he has by living in a new location. We attached the rental agreement to our answer. That's very clear that it is a complete rental agreement through RE/MAX. Yes, it is through defendant's sister and brother-in-law. However, it's a fully furnished, completely renovated carriage house in Marshall, Michigan. It's a nice place to live. He has a rental agreement, and these are his honest expenses. So, Your Honor, the request that defendant be required to pay 2/3 of this expenses is just a bit outrageous. Lastly, Your Honor, the exclusive use, as is plain in our answer to plaintiff's motion for spousal support and other relief, plaintiff has unfortunately disrupted the business a fair amount. Plaintiff had an extramarital affair that has interfered with employees at the clinic. Many employees are very uncomfortable with the situation that has arisen. The last 2 times that plaintiff has appeared at the clinic, employees were at the clinic at that time. The most recent event, police were also involved. Plaintiff has taken supplements from the clinic. Any other documents or computers that she has access to are completely unknown because she shuts off the cameras. She states she's doing that because she wants to tan, but that seems a little bit unsure. We simply just don't know because she's messing with the cameras. Your Honor, we're asking that defendant be granted exclusive use of the clinic, as plaintiff has no reason to be there. If she wants to tan, she can pay for a tanning membership at any place. She does not have exclusive rights to use the tanning machine after hours. And Your Honor, we are asking that the status quo be maintained. Defendant continue to pay his marital portion of the bills, and that plaintiff also be required to pay her marital portion of the bills. Thank you, Your Honor. I have nothing further.
Thank you. Well, what the court's going to do in this matter, the court's heard the testimony. I've already addressed the account, so that can be put in the order. The court is going to order that the defendant would continue to pay 1/2 of the mortgage, taxes, insurance, and the car insurance in this particular matter. The court would grant to the defendant exclusive use of the chiropractic clinic, and I'm not going to award spousal support at this time. I believe, obviously, with the funds that she has from the $29,000, again, the child support that she's getting and him contributing towards the marital expenses is sufficient, and the court's not going to award any more money in this matter. Mr. Todd, you can prepare that order. submitted under a 7-day notice.
Thank you, Your Honor.
Thank you.
She hasn't received a dime of her money. He now owes her $108,000.
I haven't seen the kids in 3 years. Why is she doing this at this time?
She's already owed that $108,000. Mr. Sowers is buying time so that he can get more money. I don't care, with all due respect,